Welcome everyone, I'm Russell Alexander. I've been practicing family law for over 20 years with the team at Russell Alexander Collaborative Family Lawyers. We help families going through separation and divorce. Without further ado, let's get into today's topic for our video. Court says that spousal's financial statement reads like a fairy tale. In family litigation, preparing financial statements is often an onerous task that only a few people could realistically enjoy. But once completed, the preparation and exchange of financial documents usually goes a long way towards helping resolve financial disputes between former spouses. In Ontario, under the family law rules, it is part of the mandatory disclosure process. Rule 13 provides that each spouse must provide the court and serve each other with sworn financial statements using one of several court-prescribed forms, depending on the nature of the claim that you're making or responding to. Each spouse must list his or her income from all sources, detail all living expenses, provide the value of property. He or she must also declare the value of all debts and liabilities at various points in time, including details on bank accounts, registered saving plans, credit card debts, pensions, to name a few. For claims that relate specifically to support, the rules include additional requirements. The spouse filling out the financial statement must include proof of both his or her current income and income for the past 3 previous taxation years, as established through notices of assessment from the Canada Revenue Agency and other proof of income. As we have recounted in past blogs and videos, such as financial disclosure and necessary evil in family litigation, there is a legal obligation on spousals engaged in family litigation to make full and frank disclosure. This means that financial statements must be comprehensive, inclusive, and above all, accurate and reasonable. On this last point, an older Manitoba case in Cadigan illustrated how spouses can go completely overboard with the figures they include in their financial statements, and how courts are likely to respond to such embellishment. If you're enjoying this video and find it helpful, give us a thumbs up and leave a comment below. Back to the case. The spouses, who were both dentists, had been married 27 years when they decided to separate and divorce. They had entered into a separation agreement on matters such as spousal support and had come before the court to have a final adjudication on various issues. In this context, the court received the respective financial statements, which included declarations as to their professional income arising from a dental partnership that formerly they shared and had now dissolved, as well as their alleged monthly expenses going forward. In scrutinizing those documents, the court had this to say. Each of these parties presented, as part of his or her sworn financial statement, monthly expense sheet that really reads like a fairy tale. The wife had claimed expenses of $11,000 per month, or almost $133,000 per year, more than 2 times her annual income. In this, she claims $3,400 in service of debt and $124,000 in total. As for the husband, his sworn financial statement claims monthly expenses of over $21,000 or $225,000 a year, without mentioning a penny of spousal support. According to his existing spousal support obligation, brings this amount to $26,000 per month or $315,000 per year. He has not earned income approaching that amount in any year since 1997, even when the wife's part-time dental practice raised the partnership's earnings somewhat. It is clear that not without discretionary income, it is also clear that both these parties can and do live considerably less than each claims to require. Faced with these inflated figures from both spouses, the court was prompted to add, as a result of the parties' unsatisfactory evidence as to the real needs and monthly expenses, the quantum of support that the court was asked to order is unavoidably somewhat arbitrary. The court went on to do a best guess at the various figures and the level of spousal support required, and how it should be allocated in the circumstances. For those who are just embarking on family law litigation, cases like this, one should be serve as reminders that fairy tales are to be avoided. The court might just come up with its own less appealing fiction in response. To learn more about this case, you can read the full case in the link below. Please leave your thoughts and comments below. If you liked this video and found it helpful, please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.